All right. We are good to go. Got just about 1 more minute left. Welcome Teresa from Katy, Wallace from Lake Charles, Yvonne from El Paso. So happy to have you guys join us today. I do have it is right at 12:15, so we are going to go ahead and get started. We want to give Tabitha as much time as possible to share. So welcome everyone, and thank you for joining us again today. My name is Stephanie McLaughlin, and I am the Training and Evaluation Specialist with Partners Resource Network. Partners Resource Network is the nonprofit agency that operates the Texas statewide network of Parent Training and Information Centers, or PTIs. We are funded through the Department of Education Office of Special Education Programs. Throughout Texas, we have 4 PTI projects known as PACT, PACT, and TEAM. Our mission at Partners Resource Network is to empower and support Texas families and individuals impacted by disabilities or special healthcare needs. Also joining me today from Partners Resource Network is our Director of Statewide Services, Christina Henning, our Support Specialist, Chelsea Rivas, and our Technology Specialist, Zach Hildago. If you're having any technical difficulties today, please reach out to Zach in the chat box and he can help you with those. For those of you that are needing a certificate of attendance for today's webinar, you will be receiving an email to thank you for attending the webinar. If you follow the link in that email, you can get your certificate of attendance. At the end of the presentation, we're going to have a question and answer time. If you're joining us on Zoom, please type your questions in the Q&A box. And if you're joining us on Facebook today, please type your questions in the comments and we'll be sure and get those. We are recording today's webinar and the recording will be available on our website at prntexas.org, as well as our Facebook page. And so without further ado, let me get it turned over to our speaker, Tabitha Dwyer. Tabitha is an attorney on the education team at Disability Rights Texas and a legal fellow for the Equal Justice Works. Her fellowship focuses on the representation of students with disabilities who have been unfairly or illegally disciplined in rural West Texas schools. She graduated with her bachelor's in political science from Angelo State University before earning her JD at the Texas Tech University School of Law. While at Texas Tech, Tabitha was a teaching fellow for first-year students, a research assistant, and the managing editor of the Texas Tech Law Review. She also represented clients in Texas Tech's Civil Practice Clinic. During her time as a law student, Tabitha wrote an article on Texas laws affecting drivers with disabilities, which was published in 2022. And finally, Tabitha is the younger sister of a former special education student. Tabitha, welcome. I'm going to let you share your screen and we'll turn it over to you today.
Awesome. Thank you so much for having me. Let's go ahead and get everything set up. Okay, I'm assuming that looks good for everybody. Wonderful. Okay, well, welcome to the first installment in the Knowledge is Power series. I am so excited to be here with you all today. Today is going to be all about you, parents. I am a firm believer in that one of the first steps to being the best advocate you can be for your student is knowing what your rights are as a parent. Little bit of a disclaimer, this presentation will not be exhaustive. You have a lot of rights and it's a lot to cover in just an hour. So my goal for today is just to kind of hit the high points and hopefully give you some pieces of information that will stick with you. But before we get into that, I wanted to tell y'all a little bit more about Disability Rights Texas, the organization that I work at. We are part of something called the National Protection and Advocacy System. We are the P&A authority for the state of Texas. And that makes us a little different from other disability rights organizations because we can actually monitor and investigate facilities that serve people with disabilities to make sure that they're following the law. We are a nonprofit legal firm, so we provide direct legal assistance to all of our clients at no cost to them. And you're only hearing from a small part of DRTX today, the education team, but we have lots of other teams that deal with lots of different subject matters. So we are very lucky to get to serve Texans of all ages with a wide variety of disabilities. And like I said, we provide a lot of direct legal assistance on an individual level to people with disabilities, but we also do some systemic work. For example, we have policy specialists who spend a lot of their time in Austin educating lawmakers on how certain issues impact people with disabilities. And of course, we love to educate people with disabilities and their family members about what their rights are, which is exactly what I'm here to do today. Little bit of a plug, DRTX just recently published its annual back to school newsletter. I know that in this edition, we're covering some recent changes in the law and other things like bullying. So if you're interested in that, make sure to check out our website or our socials. But enough about me. Let's talk about you. So this is our agenda, the big picture of everything that we're going to discuss today. Of course, we're going to discuss parents' rights at different points in the special education process. We're going to start all the way at the beginning with initial evaluations. We're also going to talk all about ARD meetings, the before, the during, and the after. And of course, there's a lot more to special education than just that initial eval and the annual ARDs. Your student is growing and changing, and we'll talk about how to deal with some of those changes. Then we'll sort of shift into talking about some of the problems that can arise throughout the special education process and what your rights are. We will touch on discipline and the safeguards that are available to you and your student when they get in trouble at school. And we'll also touch really briefly on some of the dispute resolution options that are available to you, parents. Finally, we will kind of close everything off by telling you a little bit about a really great resource that is available to you. It's something called the IDEA manual. And without further ado, let's go ahead and hop right into it. The first step on the road to special education is your student undergoing something called a full and individual initial evaluation, or an FIIE, because that is a mouthful. This is going to be to determine whether your student is eligible for special education, and if they are, what kinds of supports and services that they need. Now, there are two ways that this might happen. The school can initiate this process. So they might approach you and say, hey, we want to go ahead and do this initial evaluation. And at that point, they have to have your informed and written consent before moving forward with the evaluation. But the good news is that you don't have to wait for somebody at the school to suspect that your student might need SPED. You, as the parent, can also initiate this process and make that initial request yourself. Now, you can make this request in any way that works for you, but I recommend that you make the request for the initial evaluation in writing. It is always a good idea to be making that paper trail, because if something goes wrong in the future, you will have some proof of what the school district is supposed to be doing. And make sure in your request that you are including what your concerns are and why you are requesting that initial evaluation. You can make the request at any time, but I think sometimes parents wonder when they should be making that request, right? Anytime your student is struggling at school and you think that that might be because of a disability. And when I say struggling, I don't just mean academically, right? Grade slipping, things like that. I also mean struggles behaviorally or socially or functionally, things like eating or grooming, dressing, toileting. These are all issues that can be addressed and served through special education. Little bit of a warning, I want you all to be very wary of delay tactics. The most popular one seems to be something called response to intervention programs, RTI. So if you approach the school district about getting an initial eval and they tell you, well, let's pump the brakes on that. Let's go ahead and try this other program we have to see if we can get student back up to speed. It's okay to allow the district to try that program, that it is not okay to let them delay the evaluation by using this program. Once you make that request for an evaluation, that process has to begin. So you've requested an initial evaluation. Let's talk about what you can expect during that initial evaluation process. The first thing that you're going to receive from the school is something called the Notice of Procedural Safeguards. Now, for those of you who have been doing this for a while, you will know that that's that purple packet that you receive from the school at least once a year. I recommend that you keep a copy of this because what it is a summary of your rights. So it'll be good to have a copy of it to refer to in the future, should you need to. Now, you are entitled to receive this packet in your native language, and schools really don't have an excuse for not providing that to you because the packet is available for free online in a multitude of languages. And if there's anything in that packet that is confusing or that you have questions about, you are entitled to have all of that explained to you by your student's school district. Let's talk a little bit more specifically about what your rights are during the actual evaluation. You have the right to be in the know. That initial evaluation process can be really complex, and chances are they're not going to keep you up to date on exactly what they're doing. So if you're curious as to what tests are being done and why they feel these tests are necessary, you are entitled to all of that information. You also have the right to contribute to the evaluation. A lot of times what happens is the evaluator is going to give you like a questionnaire, but if you have more information to provide and that questionnaire isn't really responsive to your concerns, feel free to reach out to the evaluator to share more of that information. You can also contribute any outside data that you might have. If your student has undergone like a psychological evaluation or there's some important medical records out there, feel free to pass those along to the evaluator if you feel like those will be helpful to them. And finally, and maybe most importantly, you have the right to understand what is going on. Again, this whole process can be really complicated. So you are entitled to a copy of that initial evaluation report. And again, if there's anything in it that is confusing or that you have questions about, reach out to the evaluator, schedule a meeting so that you two can review the report together. Okay, and if your student is found to be eligible for special education, the next step is going to be scheduling that initial ARD meeting. Now, everything here applies to both that initial ARD meeting and any ARD meetings that you have after. There's two things to keep in mind when scheduling these meetings. First, you are entitled to proper notice of that meeting. Proper notice is going to be written and it's going to be provided to you at least 5 school days before the scheduled ARD meeting. Now, you can agree to a shorter time frame for that notice, and you might want to, for example, if this is an ARD meeting you have requested and there's something important that has to be discussed quickly. But just keep in mind that when you receive that notice, by signing it, you are waiving your right to proper notice if that was not given to you at least 5 school days before the scheduled ARD meeting. And just like that notice of procedural safeguards, you are entitled to notice in your native language. The second thing to keep in mind, sort of under the scheduling ARD meetings umbrella, is that you are entitled to flexibility. The district can't just reach out to you and say, hey, we have an ARD meeting this date, this time, be there, be square, right? Doesn't work that way. They have to work with you and finding a date and time that works for you as well. And they have to allow you to attend that ARD meeting in whatever way works for you. So let's say you have an ARD meeting 2 weeks from now and you want to go to it, but you know you're going to be out of town. But you also know that you're going to be able to attend via Zoom, for example. If that's the way that you can attend that ARD meeting, the district has to allow you to do so. Okay, let's talk about preparing for an ARD meeting. Little bit of a spoiler for these next few slides, but I'll go ahead and tell you that your most important right as a parent is being able to participate at ARD meetings. So let's talk about some ways that you can be ready to exercise that right. The first thing you can do is gather information. Of course, if this is an initial evaluation, you're going to want a copy of that initial evaluation report. And if there were any other evaluations that were conducted that you know are going to be discussed at that meeting, make sure that you're getting those reports as well. Other important records might include discipline records, especially if you're going to be talking about behavior at that meeting. Of course, grade reports and things like notes. Maybe your teacher, your student's teacher has some notes about them, or the people who have been providing your student with related services, any notes that they may have as well. And when I say related services, I mean things like speech therapy, transportation can be a related service, things like that. Keep in mind that the school will have up to 45 days to give you any records that you request. So if you have an ARD meeting sort of on the horizon, you might want to think about the things you're going to be discussing at that ARD meeting and kind of limit your records request based on that. Make sure that the school will have kind of plenty of time to get that to you before the ARD meeting. Another really great way to prepare for an ARD meeting is to schedule some informal meetings with important people. Keep in mind that any meetings that you have outside of an ARD meeting cannot result in changes to your student's IEP. So make sure that you're reserving those particular conversations for the ARD committee. Important people might include, of course, evaluators if there's an evaluation to review. Your student's case manager should, in theory, have a pretty good idea of what's going to be discussed at that ARD meeting, and they should be able to answer any questions you might have. And of course, always a good idea to touch base with the people that spend a lot of time with your student at school. That might be your student's teachers, or again, those people who provide related services, speech therapy, counseling, things like that. And if you do anything off of this slide before an ARD meeting, let it be that very last big bullet. Request some heads up. You can ask for an agenda, which is going to be a list of everything you can expect to be discussed at that meeting. And you can also request kind of a rough copy of your student's IEP. A draft of the IEP is going to, one, give you an idea of what it might look like by the end of that ARD meeting, but it also forces the school to be ready, right? ARD meetings are not the time to be just writing the IEP. ARD meetings are the time to be discussing that content meaningfully. So if we've gotten some of that writing out of the way, that leaves more time for those meaningful discussions. Okay, enough beating around the bush. Let's talk about ARD meetings. This is where the magic happens. And I know that some of you probably just rolled your eyes at me, and that is okay. But truly, this is where you can make a difference in the education of your student. Now, you are a crucial and required member of the ARD committee. And I've said it once, I'm going to say it again. Participation at those ARD meetings is your greatest right. So let's talk about how to exercise it. First, don't be afraid to give your input and opinions. That's why I stress the importance of preparing before an ARD meeting, because it's going to be much easier for you to discuss an evaluation if you've reviewed it beforehand and you've already asked some of your questions about it. Also, don't be afraid to ask questions. Special education is complex. We have a ton of acronyms and weird words that we use. It is the school's responsibility to make sure that you understand what's going on. And truly, there's no such thing as a bad question. I ask questions in ARD meetings all the time. Don't only ask questions, but ask for proof, right? Any decision made by the ARD committee should be based in data. If you have any questions as to the why a decision is being made, ask for that supporting data and documentation. And finally, don't be afraid to correct misinformation. You might be the only person at that table who knows really truly how something happened or how your student does at home, right? Make sure that if you hear anything that doesn't sound true to you, that you are correcting that to make sure that that misinformation isn't getting documented and then sort of follows you around for however long after. You are entitled to bring a friend with you to ARD meetings. ARD meetings can be uncomfortable sometimes, and they can certainly be scary, right? So bring your emotional support neighbor or your emotional support sister. Just keep in mind that if you are going to bring a friend, they are not automatically a member of your student's ARD committee, and they are not necessarily a participant at that ARD meeting. So keep that in mind. And of course, you are entitled to interpretation services at every ARD meeting if you need them. And the school has to provide it, pay for it, and make sure that it's all set up. So that's really important for our Spanish-speaking parents and parents who might be deaf or hard of hearing. So it is very easy and very common for parents when they go to an ARD meeting to feel like everything that is being discussed just goes right over your head. You know, you're sat at a table with all these people with fancy titles, and they're experts and they seem to know exactly what they're talking about. And if your confidence level isn't there quite yet, you might find yourself asking, when does my opinion even matter? Let me answer that question for you. Always. Your opinion always matters, friends. Because if the ARD committee is discussing something, that means it's a decision that is left up to the ARD committee to make. And again, you're a member of that committee. So you are entitled to discuss and contribute to anything that ends up in your student's IEP. You are entitled to discuss with the rest of the committee your student's PLAF. That's that first section of the IEP, stands for present levels of academic achievement and functional performance. So you get to help make sure that all of the necessary information is there. You also get to help make goals for your student and help make sure that those goals are appropriately ambitious or that they're not too challenging that your student won't ever meet them. Related services and accommodations are also important parts of your student's IEP that you get to contribute to. Related services, again, are things like speech therapy, counseling, occupational therapy, transportation. And in those discussions, you can also help decide where your student's going to get those services, how often they're going to get those services, and when those services are going to start. And finally, you also get to help the committee decide where your student, is going to be placed. You get to help the committee make sure that your student is being educated in their least restrictive environment and alongside their non-disabled peers to the maximum extent appropriate. Unfortunately, something that I hear from parents all the time are these kind of statements made to them that made them feel like they couldn't express a concern that they had or they couldn't participate. Don't accept those excuses. Anytime you hear, oh, well, we just don't do that at this campus, or we can't do that particular thing, or, well, we'll look into that, but go ahead and sign that you agree here and we'll get back to you. These are all statements that serve the same purpose, making you be quiet, right? These are all ways that schools may prevent you from participating. So just be mindful when you hear those kinds of statements. Okay, let's talk about the proper way to end an ARD meeting, and more specifically, proper documentation. I always recommend that when it starts to seem like an ARD meeting is coming to a close, that you ask for a reading of the minutes or the deliberations. And that's going to be the last section of the IEP. And it should contain a summary of everything that was discussed at that meeting. Now, after you get the reading of the deliberations, if it sounds like there's something that's missing or you want to make a correction, don't be afraid to ask for those things. You want to make sure that any agreement that was made, any disagreements that were had, and any requests that you made, and whether they were approved or denied, you want to make sure that all of those things are noted in the deliberations. Keep in mind that there might be discussions that were had or decisions that were made that quite literally can't be reflected anywhere else in the IEP because they just don't fit. So the deliberation section is the place to put those kinds of things. An example of that might be like a communication plan between you and the campus. That would be something to add into the deliberations. Now, I don't think that this happens often, but I have seen it happen, unfortunately. If the district refuses to make any of those changes or additions to the deliberations like you asked, you are entitled to write and submit something called a statement of disagreement. And this is exactly what it sounds like, right? It's going to be you writing up a separate document where you are sort of detailing exactly what it is about the IEP or about that meeting that you disagree with. You'll then submit that to the school district, and they have to then add that to the IEP. Finally, one of the last things you'll do at an ARD meeting is sign the IEP. I always tell parents that if there were 10 changes that were made at that meeting, and you agree with 9 out of 10 of those changes, but that 10th change is just not sitting real well with you and you don't agree with it, go ahead and sign that you disagree with the IEP. This is important, and again, creating that paper trail. Should this turn into a really big issue, you're sort of paving a path for yourself to maybe file a complaint later. So be very, very mindful when you are signing an IEP to make sure that you are correctly signing either that you agree or you disagree. Speaking of disagreements, let's talk about what to expect when that happens. If an ARD meeting ends in disagreement, the school has to offer a reconvene. Now, a reconvene is just a second ARD meeting to discuss the disagreement again. And the idea behind this rule is to allow the ARD committee some time to gather more information that might actually help resolve the issue. So what you can do is help the committee ensure that that recess, the period between the first ARD meeting and the reconvene, is productive. You all might decide that you need to go ahead and conduct some additional observations. You might decide that there are some gaps in the data that need to be filled, or it might be a good idea to consult with an expert, somebody who's not necessarily a part of your student's ARD committee, but can offer a fresh perspective on the issue. Whatever y'all decide to do, make sure that that productivity plan is noted in the deliberations and who is going to be doing what. Who's going to be doing those additional observations? Who's going to be consulting with the experts? Really, the only really specific rule about reconvenes is that they have to be held within 10 school days of that first ARD meeting that ended in disagreement. But you all can agree to a longer time frame. And that might be appropriate if what you all decide is necessary to resolve the issue is to go ahead and conduct another evaluation, right? A good evaluation is never going to be done in 10 school days. So in those situations, it might be appropriate to agree to a longer recess. Whatever date that y'all decide on, make sure that you're going ahead and getting that on everybody's calendar at that first ARD meeting. And finally, we made it through an ARD meeting. It is not included on this slide, but truly, the first thing you should do is go home and take a nap because that was exhausting and you worked very hard and you deserve it. But, you know, wake up the next day and start thinking about next steps. I'm noticing that it's becoming very common practice that the way we're signing IEPs is we're just sending the signature page to everybody, like via email, to get everybody's signature that way. And there's not necessarily anything wrong with that, but I think what happens a lot of times with it is that you end up not getting a full copy of your student's IEP. Just know that you are entitled to a copy of the IEP at no cost to you. And for those parents whose native language is something other than English, you are entitled to a complete and full translation of every single one of your students' IEPs. Now, I'm not just talking the template is still in English and then it's all filled in your native language. Every word on that document should be translated. Something else you can expect after ARD meetings, although not right away, is to receive IEP progress reports. These should give you an idea as to how your student is doing and progressing towards their goals. The baseline rule is that these should be provided to you at least as often as grade report cards. So I think for most districts, that's probably going to be every 6 weeks, but I have also seen districts with grading periods of 9 weeks. So if that's your district, expect to get those grade reports, those IEP progress reports every 9 weeks. That's not a hard and fast rule, however. If you are interested in getting that information more frequently, that's a discussion to have with the ARD committee, and you all can agree to more frequent progress reports. And this is actually a really good example of something that you might note in the deliberations. Okay, there is a lot more to special education than just the things that we've talked about so far, right? You know that you're going to have that initial evaluation, and you know after that you're going to have an ARD meeting at least once a year. Those are par for the course, something you should expect. But you should also expect changes. Your student is growing and learning and changing, and their IEP should change with them. This is kind of a cliche term, and I don't love to use it, but IEPs truly are and should be living documents. So if something has changed with your student or you have a new concern, you don't have to wait for that annual ARD meeting. You can request an ARD meeting at any time. When you do request an ARD, the school is going to have two options. They can either go ahead and schedule that meeting, or they have to provide you with a written explanation as to why they're not going to schedule an ARD meeting. And they have to provide that to you within 5 school days. This is a good example as to why it's important to make requests in writing, because if you request an ARD meeting in writing, it should be very clear what day you requested that. And it also makes it very clear what day the school has to get you an explanation if they're not going to schedule an ARD meeting. And of course, sometimes students change very quickly and kind of all at once. The thing that comes to mind is puberty. So that means that you might want to go ahead and get some new data to get a better idea of where your student is at that point. You can request an evaluation, any evaluation at any time. Keep in mind that the same kind of evaluation shouldn't be done more than once a year. And the idea behind that is just to create some stability in the data and to create some stability in your student's IEP. We have to allow these things some time to really work. So this seems like the perfect time to talk about reevaluations and independent evaluations. Now, when we're talking about reevaluations, we're talking about full and individual evaluations, FIEs. Now, this is sort of like a redo of what we did for the initial evaluation, except this time it's not the initial, right? That's why we dropped that extra I in the middle. The law says that these have to happen at least every 3 years, but then it kind of carves out this exception. The ARD committee can agree to forego that reevaluation if it determines that that's not necessary at that time. The way that that decision is made is the ARD committee is going to conduct something called a READ. That stands for a review of existing evaluation data. I know, another acronym, you're so excited. Now, 9 times out of 10, the school isn't going to want to do an FIE. The good news is that you don't have to agree to forego that reevaluation. If you want to go ahead and go forward with the FIE, the school then has to follow your lead and go ahead and conduct that reevaluation. If at any point in time you don't agree with an evaluation that the school has done, and that can be an FIE or a more specialized evaluation like a functional behavioral assessment, you have the right to request an independent educational evaluation, IEE. If you're going to go ahead and make that request, the school has the responsibility of telling you how to get one. Most of the time, the way that I see this done is school districts will have a list of the service providers that they know will do independent evaluations. Just know that you don't have to use that list if you don't want to. The bad thing about independent evaluations is that they're expensive. The good news is that you can sometimes get an IEE at public expense. So that means that the district would be the one paying for it. You always have the option of paying for your own IEE, but the way that you get one at the district's expense is you disagree with the school's evaluation first. And for every evaluation that the school does, you get one IEE at the district's expense. Something to be aware of is that if you do request an IEE at public expense, the school district will have the option of filing for due process to try and prove that their evaluation was adequate and to try and get out of paying for one, for paying for an independent evaluation. So definitely something to keep in mind when you are requesting an IEE. Okay, now we are shifting to sort of the second part of the presentation, parents' rights when problems arise. I wanted to touch on a couple of different forms of discipline and the procedural safeguards that are in place for all students, not just special education students. I think school districts sometimes have a tendency to overlook these things when it comes to special education students. So let's talk about that. If your student is suspended, the school's responsibilities in that situation are pretty minimal. All the school has to do when it decides to suspend your student, and that can be either in school or out of school, they have to provide you with prompt notification. Prompt means by 5 p.m. the next business day. So if they decide to suspend your student on a Friday, they have to give you that notification by 5 p.m. the following Monday. They have to give you that notification in 2 ways: verbally, so either over the phone or in person, and in writing, so either an email or a letter. Texas law strangely lumps in arrests at school with suspensions. So unfortunately, the responsibilities of the school when your student is arrested at school are pretty lax as well. All they have to do is give you that prompt notification. If your student is assigned to a disciplinary alternative education program or a DAEP, you and your student are entitled to a conference. Most of the time, this is going to be with your student's principal. This has to be held within 3 school days of the change in placement to the DAEP. And the school has to invite you to this. This conference can't ever be held just between the principal and your student. You have to be invited. At that conference, they have to provide you with written notice as to why your student is being sent to a DAEP. And at that conference, they have to give you and your student the opportunity to respond to that reason for removal, kind of defend the student, right? Moving on to expulsion. Again, these are things that apply to all students, whether they're receiving special education or not. If your student is expelled, expect this process to be a little bit more formal, right? Instead of a conference, you're going to have something called a disciplinary hearing. Now, this has to be held before your student is actually withdrawn and expelled. And the school has to invite you, but they don't have to wait for you. We're not looking at the same sort of flexible scheduling standards that we see for our meetings. This is truly going to be, hey, here's the date and time, be there or be square, right? So when you receive that invitation, do everything that you can to attend that meeting if possible. Keep in mind that whoever is conducting the hearing has to consider any disabilities that your student has in making that final expulsion decision. So you have the right, because you have the right to represent your student at that hearing, to make sure that the people making that decision are aware of your student's disabilities. Sometimes it's also best to speak on your student's behalf and ask that they sort of release those reins to you. So that is your right. You get to represent them at the hearing and speak on their behalf. There are some appeal options that are available to you when expulsion happens, but these are going to be specific to your district. All districts have a local level grievance procedure, and we'll talk a little bit more about that in just a minute. But some districts also have an appeal process that is more specific to disciplinary decisions. So if you're going to appeal, make sure that you're checking out your district's policies and that you're being mindful about timelines. 9 times out of 10, you're going to have very limited time to file that appeal. So keep that in mind. Still talking about discipline, but now talking specifically about the protections in place for students with disabilities. There are some times where students with disabilities are entitled to something called a manifestation determination review, or an MDR. This is a protection for students with disabilities because what you're doing at that meeting is if you decide that the student's behavior that got them in trouble is actually a manifestation of their disability, your student cannot be removed from their regular setting, right? Now, these don't happen every single time your student is removed. We're looking for that threshold of 11 or more days removed from their normal setting. So you have to hit that threshold first. You might hit the threshold either by removals kind of all at once, right? So if your student is assigned to a DAEP for 15 days, that's going to trigger a manifestation determination review. But it can also be a pattern of removals. If your student is removed for a chunk of days here, a chunk of days here, let's say all in a semester, and you get to that 11 or more school days, that might also trigger an MDR. These have to be held within 10 school days. And the school kind of has to treat it like an ARD meeting, and that they have to invite you and they have to be flexible in scheduling the meeting to make sure that you can be there, right? So just like the school kind of has to treat it like an ARD meeting, I want you parents to do the same thing. You can prepare for that meeting by requesting and reviewing and bringing along with you any relevant documentation. My recommendation there is definitely your student's IEP, any behavioral intervention plans that they might have, any behavioral data, so like a functional behavioral assessment, and discipline records. All of those things might be helpful to you in deciding whether that behavior was a manifestation. And be ready to discuss how your student's disability affects them specifically. Your job at an MDR is to help the committee decide whether that behavior was a manifestation. And treat it like an ARD meeting in every other way in addition to preparing. Make sure that you're reviewing deliberations at the end. Make sure that everything is getting documented correctly. And most importantly, if there is something that you don't agree with, sign that you disagree. Okay, so let's talk about, very briefly, some of the dispute resolution options that are available to you all. As a parent, you have the right to pursue all of these options, right? I've divided them between the basics and the more complex options. The basics are going to be the options available to you that are a little less intense, a little less time-consuming, whereas the more complex options are going to be much more time-consuming. There's going to be a lot more rules that go into those things, and they can even be more expensive. So let's start on the left side with the basics. ARD facilitation and mediation are both really great ways to keep an issue within the committee, but you're bringing in a third person to help you all try and find some middle ground. The difference between these two options is that ARD facilitation, because you are requesting it through your student school district, is probably not going to be an independent third person, meaning that it's likely going to be a district employee. Mediation, on the other hand, which is provided for free by the Texas Education Agency, that will truly be an independent third person, somebody who is not affiliated with the district in any way, shape, or form. The way that you go about requesting mediation is by filling out an online request form on the TEA's website. And just keep in mind that in order to go through with mediation, both parties have to agree. So both you and the school district. The last basic option that you have are those local level grievances. Now, this is a process that is totally local to your district. So make sure that you're checking out your district's policy to make sure that you're falling within all the timelines, doing everything that you have to do. And I think that local level grievances are a great way to address issues if certain policies aren't followed. A lot of the time, schools aren't following policies as to bullying. So filing a local level grievance on that particular issue is a good way to resolve that. And if you are having any issues with particular staff or personnel, a local level grievance might be a good option for you as well. Those more complex options, let's start with a written complaint with the Texas Education Agency. This is more complex because there's kind of a lot of hoops that you have to jump through in order to get the Texas Education Agency to actually investigate your complaint. the most important thing that I want you to keep in mind, if you know nothing else about filing TEA complaints, is that you have to file it within 1 year of the thing that you're complaining about happening. So 1 year statute of limitations. Keep that in mind if you're considering filing a complaint with the TEA. And finally, the most complex option that is available to you is a due process hearing. I always caution against these. They are very intense, very time-consuming, and expensive because they're basically like court hearings, right? So be ready to sort of dedicate those resources if you're going to go through with a due process hearing. And also know that historically, school districts win these things, right? They have all those resources available to them all the time. Now, all of my warnings out of the way, if this is something that you want to pursue, the way that you do that is you fill out the online notice form that is available on the TEA's website. And probably the important thing to keep in mind with due process hearings is that it is the only resolution option available to you that can invoke something called stay put. If you invoke stay put, that means that your student stays in their current placement and continues to receive all of their current supports and services. So this might be an option for you to consider if your student's placement is being changed, either for an academic reason or a disciplinary reason. And lastly, I want to tell y'all a little bit more about a fantastic resource that is available to you all, the IDEA manual. Now, this is available on Disability Rights Texas's website, and it covers everything that I talked about today in so much more detail. And it also talks a lot about students' rights throughout the special education process. Not only does it have all of this really great information, but it also includes how-tos, sample letters of ways that you can request certain things from school districts. And of course, it also points you to other additional resources should you want to dig in deeper into a particular topic. Okay, and if you find yourself in need, I just wanted to provide you a way to contact us and to have access to our services. So write this down, keep us in mind if you ever need anything. And with all of that being said, I feel like that was super fast and furious. So I hope that you caught some of that. And I think that we have a little bit of time for questions, right, Stephanie?
Yes, we do. So a
Wonderful.
reminder, if you are joining us on Zoom, please put your questions in the Q&A box so they don't get lost in the chat. And if you're joining us on Facebook, you can just put those in the comments and we'll catch those. We have a number of questions, so we'll see what we can get through as we have time. And so the first question, you just talked about the IDEA manual, and I did put a link for where you can access that manual in the chat and also on Facebook. Is the IDEA manual specifically for Texas?
It is, yes. So it was developed by a couple of Texas-based organizations, right? Disability Rights Texas and the ARC of Texas. They kind of co-authored this big old packet. Now, even though it is specific to Texas because it has some kind of Texas-specific state law things, it also covers a lot of federal law, like the IDEA. And so that is going to apply to every state in the country. And I'm pretty sure that the manual is really good about making sure that you know what is a federal requirement and is going to apply to other states versus what is a requirement that we only have in place in Texas. That was a great question. I know that the title of the manual can be maybe a little misleading.
Absolutely. We have so many great questions. So the next one, what if a parent is not given a copy of the IEP at the end of the meeting? And so when they get it afterwards, things are different in the actual document than what was discussed in the meeting. What do parents do in that case?
Yeah, so something you can do to sort of prevent that from happening, right? At the end of a meeting, the district is probably going to ask you if you want to waive your 5 days, right? If you waive your 5 days, the IEP, as it's written, goes into effect that day. You do not have to waive those 5 days. If you want those 5 days to be able to obtain a copy of the IEP and actually review it in depth before signing it, that is an option available to you. If it's that you just are ending up without a copy of the IEP and there's not necessarily an issue as to, making sure that everything was written down correctly, you can absolutely reach out to the special education department or your student's case manager in order to get a copy of the IEP quickly.
Thank you. So one from Facebook. How do parents sign that they disagree with the IEP, but still ensure that the parts of the IEP that they do agree with are still implemented?
That is a fantastic question. So usually what we see when we're signing IEPs is, you have the signature box and then it's just the two little boxes beside it that say disagree or agree, right? The deliberations is going to be the place to note specifically what parts of the IEP you disagree with. So it'll be clear what those 3 things are that you disagree with versus the 7 things are that you do agree with. The good news is that regardless of whether you agree with the entire IEP, a lot of times the IEP is going to go into effect anyway, right? If you have a reconvene to try and sort of, wrestle out that remaining disagreement, that's going to set you back a little bit, right? But don't worry, because the things that you do agree with are going to go into effect. The bad part of that is that the things that you disagree with are also going to go into effect. So my biggest advice to you is just make sure that what you disagree with specifically is noted in the deliberations.
Absolutely. So great question. Do charter schools have to follow the same obligations and rules as the public schools?
That is a very big question. So it really depends on what kind of charter school, right? There are a ton of charter schools that are still technically part of like a public school district. Like in my area, Midland ISD, they have this charter school that's called Carver Center. And I'm talking about them specifically because they like blow state tests like out of the water. They're pretty well known. They're like a satellite school, right? They're technically like sort of their own thing, but they're also part of the district at large. If that is sort of the case, the charter school is tied back to a public school district. All of the same laws that apply to public schools are going to also apply to charter schools. So without getting too into the weeds, that's probably the best and most accurate answer that I can give to you for that question. But it's a great one. And if you're interested in that, I encourage you to like look it up, research it. There's a lot of interesting stuff there.
Absolutely. I'm trying to pick some out. We have so many questions.
That's good.
And so another question, somebody said their son is about to turn 18. So is there anything that they need to do in that process? And 2 main questions. Will the parents be notified of ARD meetings after their child turns 18? And then the second one, will they be able to make any of the decisions once their child turns 18?
Okay, so there's a lot there. If we're only talking about what your rights are going to be as a parent once your student turns 18, you will be notified before your student turns 18 that when they do reach that age, all of the educational decision-making power that once belonged to you is going to automatically transfer to the student, right? And we know that that's not always appropriate, and it is sometimes best for you to continue to be involved and to at least help your student make educational decisions. A lot of times what I hear is that schools tell you that the only way to keep participating is through guardianship. That is not true, and it's actually illegal for them to talk to you about guardianship and not talk to you about alternatives to guardianship. If you are concerned about retaining some of that educational decision-making power, I definitely encourage you to look into something called a supported decision-making agreement. This is something that you and your student, once they turn 18, can execute together. And that basically says that you, parent and child, adult child at this point, right, share decision-making abilities. So if you have that in place, for example, that would allow you to continue to go to ARD meetings as your student supporter to continue helping them in that process. Did I cover that? That was a dense question. Okay.
That is.
I didn't want to lose the plot.
Absolutely. And so we have a lot of questions. I apologize that we don't have time to be here all day and answer all the questions, but you can absolutely reach out to us. So let's end with one final question. Can you just talk very briefly about a parent's right to record the ARD meetings? And second part of that, if the school records the ARD meeting, are parents given the right to get a copy of that recording?
Yeah. So that's kind of an easy question because you absolutely have the right to record an ARD meeting. There's nothing anywhere that says that you cannot do that. If you are being told that you cannot record an ARD meeting, I would encourage you at that point to start looking into those local level grievances, right? That might be a good way to resolve that particular issue because it's just not true. You can record. If you sort of rely on the school district to record that for you, that is then an educational record. And it sort of falls into the same category as anything else, right? IEPs, discipline records. So if you want to get a hold of that, I recommend that you just request it. Do it in writing. The school will have up to 45 days to provide that to you. If they don't, an option that is available to you at that point is filing a TEA complaint. And I know we didn't get to talk about that very much, but again, check out the IDEA manual, and there's lots of other resources out there that'll help you figure out how to do that.
Absolutely. Thank you so much, Tabitha. In the interest of time, we're going to go ahead and wrap up today. So I'm going to share my screen and wrap everything up for us today. So again, I want to thank you all for joining us for today's webinar. And I want to thank you, Tabitha. Fantastic information that all parents need. Knowledge is power, and that's the whole point of our series. And so thank you again. As a reminder, we did record today's webinar, and the webinar recording will be available on our website at prntexas.org, as well as our Facebook page. If you're needing a certificate of attendance for today's webinar, you will be receiving an email to thank you for attending the webinar. Follow the link in that email and get your certificate of attendance. Knowledge is Power is our multi-agency collaborative webinar series. Joining us also, along with Disability Rights Texas, will be West Texas A&M University Center for Learning Disabilities, the University of Kansas, Texas A&M University AgriLife Extension Services, Texas Council for Developmental Disabilities, Cadre, the Center for Appropriate Dispute Resolution in Special Education, and more. So check out our series. Upcoming webinars on September 17th, What Should Be in My Child's IEP with Dr. Michelle Simmons from West Texas A&M University Center for Learning Disabilities. On October 1st is Smart Transitions, Leveraging Assistive Technology for Success with Dr. Sean Smith from the University of Kansas and President of the National Down Syndrome Congress. And on October 22nd, Addressing Behavior Needs with Dr. Laura Kern from the University of South Florida. We're also going to have on October 29th, Let's Chat, communication strategies are key with Dr. Morgan Foster from Texas A&M AgriLife Extension Services and the Texas Council for Developmental Disabilities. And we're going to wrap up this series on November 12th with Resolving Conflicts Constructively. Informed Parents Make Informed Choices with Dr. Timothy Hedin, Cadre Senior Consultant. On the screen is contact information for our Director of Statewide Services, Christina, our support specialist, Chelsea, and myself. Please check out our website again at prntexas.org for information on upcoming webinars and events in your local regions, as well as lots of information for parents. You can follow us on Facebook and X at PRN Texas. Thank you again for joining us. Tabitha, thank you again. Always a pleasure to have you join us.
Yes,
And
this was a blast. It's always a blast. I always love seeing your smiling face and everybody else. So thank you so much. And I hope to do this again with you all very soon.
absolutely. We love having you join us. So thanks again.
Awesome. Have a good one.
You too.
Bye.
Bye.
Thank you.